So, good evening, everyone, and thank you. And welcome back to today's discussion. We are going to discuss about liquidated damages. So, as we all know, that liquidated damages is a issue which is being quite contentious. इसको लेके बहुत सारा litigation भी हुआ है. तो आज हम लोग उसी के बारे में थोड़ा डिटेल में डिस्कस करेंगे. So, where did the problem start from? Agreeing to the obligation to refrain from an act or to tolerate an act or a situation or to do an act. This was declared as a part of the supply definition. Okay. Like when section 7 had included this part that, that schedule 2, whatever supplies I mentioned in schedule 2, so there will be either supply of service or supply of goods. But from 1st February 2019, there is an amendment in this. And to that extent, what has happened is that it has been actually dissected. So supply has to fulfill the definition of supply first, and then only if it fulfills the definition of supply, then we are going to see whether it is a supply of goods or supply of services. So because of the huge number of litigations on liquidated damages, the 47 GST Council took the matter in the agenda and they discussed on this. And they came up with a clarification via circular number 178 of 2022, wherein they have clarified as to what are the areas which are going to be taxed under GST and what are going to be outside the boundaries of GST. So first is that, what they've said is that they have given 3 types of examples, like agreeing to the obligation to refrain from an act. So it is something about which I'm not doing, right? So I am telling that if you give me this compensation, I am not going to do this. So it could be a non-compete agreement. So a lawyer or another engineer may agree that, okay, that we are not going to work on the same building, okay, since we are working here. So maybe you're not going to give, engineering services, or you're not going to be in this particular office, or you're not, or maybe two different IT companies, they are saying that, okay, we are not going to do this particular software, So wherein there is a non-compete agreement coming in, that we are not going to be a part of the competition. And for that, some amount is paid, okay, that will not be treated as a consideration. Second is a builder refraining from construction. Say a builder is saying there is a huge ground and the builder is saying that, okay, I'll not construct more than 4 floors here. Why? Why am I not going to construct more than 4 floors? The reason being that the air and the light should go to the buildings which are there, next to the building which is being constructed. The third could be an industrial unit refraining from manufacturing activity during certain hours. So there is a residential area and a new manufacturing setup has come in, and they have agreed that they are not going to work beyond 6 p.m. Though legally and commercially they can work, but just because of the neighborhood issues that happen, so they've agreed that on a month they'll be getting a certain fixed amount of compensation from the neighboring residential, maybe the conclave or the residential complexes, that they are paying certain amount to this particular industrial activity, industrial manufacturer, so that he doesn't manufacture that. The second type of example could be the agreeing to the obligation to tolerate an act or a situation. So if it so happens that a shopkeeper is allowing a hawker to operate from a common pavement, so the shop is there, in front there is a huge footpath, but the shopkeeper is allowed a hawker to sit there, and in lieu of which hawker is actually paying a certain amount to the shopkeeper. So here, since the place is not owned by the shopkeeper, he cannot give it as a rent. Okay, but he's agreeing to the obligation to tolerate the act of the hawker sitting there, right? Similarly, agreeing to the obligation to do an act. So here, what is happening? That, okay, so industrial unit is agreeing to install equipment for pollution control. Okay, why? Because the neighboring residential welfare association, they have complained They have complained to the different forums and they have said that, okay, only if you're installing this pollution control equipment, then we are going to actually, allow you to operate from here. Okay. And because of this, they are actually installing the plant, though they did not legally have to do it. So it's an agreeing to the obligation to do an act. That is to set up that pollution control equipment. So some more examples are given of this issues during the service tax or GST demands, which is liquidated damages for breach of contract, compensation given to allottees of coal blocks, check dishonor charges deducted by bank, penalty paid by mining company to state government, okay, for unaccounted stock of riverbed material which is there, bond amount recovered from employee who is leaving the agreement before the said agreed period. So there is an agreement for 2 years and the employee is suddenly leaving after 6 months. So he's giving the bond amount. So on that, what would be the implication of the tax? Late payment charges collected by the service provider for late payment of bills. And fixed charges collected by power generating companies from state electricity board or discoms, from individual customer for supply of electricity. So all these issues are there. It needs to be discussed straightway. And the circular in question has discussed all these questions straightway. So first, what has been shared is that agreeing to the obligation to refrain from an act or to tolerate an act or to do an act in para 5E of the Schedule 2 of CGST Act is in line with what the contract act says. Okay. So in contract, what is there? Contract is a set of promises forming consideration for each other and wherein there is an acceptance, either verbal or written. And in terms of the parties doing for each other, there is a consideration flowing out of the particular agreement. Okay. This goes to show that the service of agreeing to the obligation to refrain from an act or tolerate an act is nothing but a contractual agreement. Okay. So it's a contract that if you do this, then I'm going to do this. So when in the case of a non-compete contract, two companies are telling that, okay, if you are going to operate in this particular jurisdiction or territory, I'm not going to operate in this territory, subject to you giving me this particular compensation. Okay. So then going forward, so what is a contract? An agreement enforceable by law. In other words, we can say that a contract is anything that is an agreement. So there are two parties which are present and there is an offer and acceptance. Okay. And it should be enforceable by the law of the land. That is the most important. So it's not something which is not legally enforceable later on. So here, in terms of the liquidated damages, a contract is essentially standing there. So a contract is must in the case of all the situations that we have discussed, whether it's to refraining from an act, tolerating an act, or obligation to do any act. Okay, so there is a contractual obligation between the parties to do something and to not to do something in exchange of getting something in return. So we have also seen in section 25 of the Contract Act, it says no consideration, no contract. So ideally, if there is a contract happening between two parties, okay, the example of the hawker and the shopkeeper. So there is a contract between both of them that the hawker is going to sit in front of the particular shop, and in lieu of that, he's going to give some compensation to the shopkeeper. Okay, so there is a flow of consideration that is happening from one person to another. Okay, and so what are independent arrangements? This is again an area which is very dark. I think there's a gray area being created through this. In my personal view, because whatever views I'm expressing here, these are all personal views. So here they're saying that such contractual arrangements must be an independent arrangement in its own right. So they cannot. So a person can be said to be making a supply by way of refraining from doing something or tolerating some act or situation to another person, if the first person was under an obligation to do so and then performed accordingly. Okay, so that is very important what they are saying. What has been clarified here, I think this is a difficult proposition because an independent arrangement will not always arise. Okay. So similarly, I'm into a contract. I've got a professional service from a government body, and that government body wants me to do the thing in time, on time. So they have put in a condition that if I don't do the thing on time, they are going to levy a damage, liquidated damage of say 1,000 rupees per day. Okay, for the delay in completion of. So is this an independent arrangement? This is a part of the system. So, but again, this is a compensation that this is not a consideration. So, I'm essentially not rendering any service to the government. So that is, that is what has been cleared here. That as has already been stated, unless payment has been made for an independent activity of tolerating act under an independent arrangement entered into for such activity of tolerating, such payments do not constitute consideration, and hence such activities will not constitute supply. So if I am doing something in terms of a contract, okay, like payments as liquidated damage for breach of contract, penalties for the Mining Act of excess stock found, forfeiture of salary for leaving the job, penalty for check are not consideration for tolerating an act or situation. They are amounts received for not tolerating an act or situation or breach of act. So these are mere events in a contract, and they are in the nature of compensation, and they are not a consideration. Okay. So then they have been discussing about liquidated damages. Okay. And we have gone into discussion of section 73, where it has been held that when a contract has been broken, the party which suffers by such breach is entitled to receive from the other party compensation for any loss or damage caused to him by this breach. So, friends, it is just been clarified that a liquidated damage is nothing but a compensation received by one party because of the damages that he has suffered, either because of the delay or because of the non-completion of the job the proper way. Okay. So liquidated damages are a measure of the loss and damage that the parties would agree would arise due to the breach of the contract. They do not act as a remedy for the breach of the contract. So it's not that, since you have created this breach of the contract, since I have delayed the filing of the report maybe by 10 days, okay, it does not redress the grief that is being, that is suffered by the service receiver. It is, it is nothing more than the compensation for the damages that that person may have faced. So it is not going to give back the original position. So just by deducting this compensation from the fees that I'm able to get or I'm supposed to get, it is not that they're getting the fee, they are getting the report within the due date. Okay. So rather, this is a deterrent. This is a deterrent so that I finish the work on time. So now, after this, some of the important examples have been discussed here. So, say earnest money, forfeiture of earnest money by seller in case of breach of an agreement to sell an immovable property by a buyer or by government or local authority given a successful bidder for allotment of natural resources is a mere flow of money, as the buyer or the successful bidder does not get anything in return for such forfeiture of earnest money. Okay. So whenever an earnest money is forfeited, so that is not a supply. And that's why there is no levy on that particular thing. So maybe I'm a government body and or maybe I'm a body which is called for some tender. There is the earnest money, and since the tender participants they cannot fulfill the condition, I had to actually forfeit the earnest money. So in this case, it has been clarified that this is just a compensation and this is not a consideration because I am not providing any service to the person who is participating in the tender. Okay. A contract may provide that payment by the recipient of goods or services shall be made before a certain date, and a failure to make payment shall attract late fee or penalty. Similarly, some other examples have been given. So we will just quickly go through each of the examples. So check, dishonor, fine or penalty. So we need to understand that the fine or the penalty, this is very important here. The fine or the penalty that the supplier or banker imposes, the fine or the penalty that the supplier or the banker imposes for dishonor of a check is a penalty imposed not for tolerating an act, or penalty imposed for not tolerating, penalizing, and thereby deterring and discouraging such an act. Therefore, this is not a consideration. Okay, so they are not charging it as a charge just because they are tolerating some act, but they don't want others to dishonor the check. Similarly, penalty imposed for violation of laws, okay, like the traffic laws, and here it has been said in a wonderful way that for violation of pollution norms or other are not consideration for any suppliers. Okay, so whatever penalties are being imposed for violation of the laws, okay, so there again no penalties. So they are not a consideration. then again a compensation. So if you have not fulfilled the pollution norms and a penalty has been imposed, that is not a consideration, that is not a supply, and no RCA needs to be paid on it. Right? Yeah, so this is a clarification that was there in the service tax era also, when it has been clarified that these do not fall within the ambit of the consideration or payment of service. Next is the forfeiture of salary or payment of bond in the event of employee leaving the employment before the minimum period. So here it has been clarified that such amounts, the said amounts are. So what has happened? Mr. X, he was there for 2 years. He has suddenly left the company. Okay, and within say 6 months. So in this case, the said amounts and the company has recovered the bond amount from the particular person. So the said amounts are recovered by the employer not as a consideration for tolerating the act, but as penalties for dissuading the non-serious employee from taking up employment and to discourage and deter such situations. So when I'm forfeiting the bond amount for a particular employee, it is not a service that I'm rendering. It's just a compensation. And why am I doing this? So that others are tempted not to do this in the future. Because they know that if we leave the bond period in between and leave it and go away, then our bond amount will also be forfeited. So it acts as deterrent. Okay. And therefore, it is nowhere a supply. However, we need to see that in my view, for notice pay, wherein the person was supposed to, leave the service, say with a 2 months notice, and the person leaves with the notice period of only 10 days. In that case, whenever there is a salary deduction, say for 1 month and the remaining 1 month, 20 days. So in my view, that is also a compensation, and that's not in the nature of consideration because that is again a deterrent to all the employees so that they serve the full notice period, and therefore that is also not a supply. Okay. Then next is the compensation for not collecting the toll charges. So again, a huge question arose here whether compensation paid to concessionaire by project authorities in lieu of suspension of toll collection during was taxable by way of service. So here we need to understand that during the period, the service of access to road continued to be provided with the collection of toll from suppliers. Okay, and here we need to understand that this particular toll amount, which was to be the consideration came from the project authority. For the same consideration came from a person other than the actual does not mean that the service has changed. So here, the facility of accepting here regarding the toll fact, what has been said is that the toll charge was paid as compensation by NHR as the instruction for Ministry of Transport and the Highways. So here the toll amounts were not as a compensation, rather they came as a consideration. Okay, so they got the amount. Okay, that the service is provided by Volta is that of excess toll charges be merely a consideration for that service. So here they are saying that this is something they would have got normally, and they have got it as a compensation because of the invoking of the period of non-collection of toll charges by the concessionaire just because of the demonetization. Okay, so that is not a compensation. That is a consideration they have received, and they have received it from a different person. So that charge does not change the nature of the service. Next, they have discussed about late payment surcharge of fees. So here we need to understand that it's ancillary to and naturally bundled with the principal supply of such of electricity, water, telecommunication, cooking gas, etc. It should be assessed at the same rate as the principal supply. However, the same cannot be said of the check reserve. So here it is very important that in some cases the late payments are accepted without late payment fee or a fine or a penalty. And in this case, it is not a compensation. Here it has been opined that it is in tandem, it is in connection with the original supply, and therefore it will be subject to levy, and it will be included as a part of the original supply, and tax will be charged accordingly on the entire supply. Okay, so this is not a consideration. This is not a compensation for tolerating the particular act. This is not a deterrent. This is something that they're getting in lieu for. They're getting just because there is a delay in the. Okay. Then the fixed capacity charges for power. So this is about the power sector in general that you have to. There is a fixed capacity commitment which is there. So both the components of the price, the minimum fixed charges, capacity charges, and the variable energy charges are charged for sale of electricity and thus are not taxable as electricity is exempt from GST. So we need to understand that even though the electricity, since the electricity charges are themselves outside the ambit of GST because they are exempted. Similarly, even if the fixed capacity charges which are given to the electricity companies to cover up their losses of fixed overheads, that is also in the nature of electricity charges, and therefore, that is also exempted. Okay, such agreements which ensure assured supply of power to state board are ancillary agreements that contract essentially for supply of electricity. So if I don't give the minimum guarantee amount to these discoms, then they're not going to survive. And that's why this is there. And so it is opined that this is not going to be, this is not going to be in the nature of uh, levy because this is included within what is known as the electricity services, the electricity charges. Okay. Now, next comes the most important sector, which is the cancellation charges of the tourism sector. So here it has been held that services such as transportation, travel, and tour considered bundle of services. Okay. So it's happening together. And it has further been said the supplier may allow cancellation of supply by the customer within a certain time period on payment of cancellation fee in terms of commercial terms of the contract. Okay. And if the customer does not show, then he is going to be deducted that particular thing, the cancellation charges. So here it has been held that the facilitation service of allowing cancellation against payment of cancellation charges is a natural part of the bundle of supply that he is supplying. Okay, so it's invariably supplied by all suppliers of passenger transportation services in conjunction with the principal supply, and therefore it has been held that cancellation charges of railway tickets for a class would attract GST at the same rate as applicable to the class of travel. So, for the travel sector, friends, we need to remember that for all cancellation charges that you're deducting from the customers, you need to also levy GST on the cancellation charges. Okay, that's a view that has been given in the particular circular. Though in some quarters there is a view that when I'm cancelling the ticket, when I'm canceling the tour, how am I actually providing a service? Because I'm actually not providing any service, and that's why I'm just taking the fees that I've rendered for cancellation of the entire because of the effort that because if I was giving the contract, if I was fulfilling the contract, if I was giving the toll supply, to service to the particular customer, in that case, I would have charged the GST, it would have been income to me. But now I'm cancelling the entire tour, I'm just charging the cancellation fees. Okay. So on that, in many quarters it has been raised, the question has been raised, why GST has to be charged because there is no supply. But having said that, the circular has clarified that there will be a GST on the cancellation charges. Next, cancellation of property flat. So forfeiture of earnest money by a seller in case of breach of agreement of removal property in the event of success. So that will is a mere flow of money. So it's not a contract. It's not a contractual payment. It's a compensation. So it's not a consideration for tolerating the act, but it's a compensation for the losses suffered and a penalty for discouraging the non-serious buyers or bidders. So in this case, we need to understand that whenever a cancellation of flat is happening, okay, and whenever some forfeiture is made, say 1 lakh rupees is made, that the view has been given is that in that case, the forfeited amount will not be treated as a supply and no GST needs to be levied on that forfeiture. So we have some authority for advance ruling in relation to cancellation of air tickets and hotels and these are there. So I will be sharing the same. This was there when it was held in many cases that it's a service and so it will be a supply of service. So now the question is being raised that wherein the unit is being held as a service, it is being held as a supply of service by the authority for advance ruling. Okay, and say the authority, you went to the authority for advance ruling, and they have said that so this is something that you need to levy GST on this. So in that case, in those cases, whether after the circular has come, it is clarified that no GST has to be paid on that. So what will the applicants do who have applied for the advance authority for advance? Okay. So we had a discussion in one of the groups today. So in my view, first is that you can go for the appeals, which is there with that authority for advanced appellate authority. That this was there at that point of time, but now the circular has come, so we are again filing the appeal. So the appellate authority may say that okay, it is not a supply, and so no GST needs to be paid on that based on the clarification given. We can also approach if the time for appeal to the authority for advanced appeal is gone. In my view, we can also approach the High Court saying that it will be violation of Article 14 because somebody who has not gone to the authority for advance ruling will be not paying GST on liquidated damages, but says I had gone to the authority for advance ruling and therefore find that there is a supply. The opinion which has undergone a change maybe today by the circular issued. So will I have to pay the GST of that? So that could be the question that could be put forth. Okay, and third view is that this is a kind of change in the circumstances because there is a clarification to the effect which has been brought by the government, by the authorities, which is a delegated legislation, which is a part of the view of the legislature. So that's why, maybe the view of the circular to be taken up, even though the authority for advanced ruling had opined that it will be a taxable supply. Having said that, these are my personal views. Please do take a professional view from the person you could rely on and take that view and then move forward on that. So, if I have to go in a summary in a nutshell, liquidated damages per se are compensatory in nature, which has been our argument for the past 5 years that they are compensation and they are not consideration. Secondly, one of the important things is for the tourism sector, they need to be very careful because even if you are doing cancellation of services, there also it has been opined that it's supply of service, and so GST needs to be levied on that. So with this, I would close my deliberation for the day. And in case there are no queries, you could always mail to me at gstwitharup@gmail.com. I would be more than happy to reply to your queries on this. Thank you very much and have a wonderful evening, day, or afternoon ahead.